Yes, perfect. So I'll make it official. Hi again. Welcome to the fifth session of Startup School Schools. It's only the fourth because the fourth session is going to be tomorrow. But on our agenda, this is the fifth, and I'm super excited to welcome our friends and partners from Cobalt. We actually have not only one or two or three mentors, but four of them this week. So a lot of your questions can be answered right away, as there are different specialties covered, and I couldn't be more happy about the collaboration TechHub's always had with Cobalt on whatever questions we have. So I hope and I know that they will be a huge help for you also. On all of your specific business cases. So feel free to write down some questions or keep them in mind for your one-on-one sessions that we will schedule in a bit, and hope to make the most of it. So I'll give the floor to the mentors and let them introduce themselves, and hope you enjoy the session.
Thank you, Anna. I will take over from here as the first speaker on behalf of Cobalt. Maybe some of you know what Cobalt is. For those who don't, Cobalt is one of the top law firms in not only in Latvia but in this region, in Baltics, Belarus, and. We would like to think that we have not just know the theory, but we have also gathered some experience, and we are rather startup friendly. Otherwise, we wouldn't be here to share this experience. And I can say, at least on my behalf, that I'm really happy to always to talk to startups, to young businesses who are active and whom we can just help by by telling what we know. Today we have some topics. But yeah, on the agenda, which you see on the on your screens. First, I will cover the intellectual property matters. Then my colleague Toms will go on legal entities and shareholders agreements. And together with Sandy, also on taxes and stock options, and finally Gabriel will take care of data protection. I think it would be more fair that everybody introduces a little bit of him or herself. Otherwise, you will forget all the fancy titles. And I will just take care of myself. So not too much to tell about myself. I'm lawyer here in Cobalt, partner, co-owner. Sometimes I'm also angel investor and mentoring startups. And my core knowledge is related to IP. And also from time to time, I'm doing transactions with the venture capital. So therefore, I would like to think that I more or less know the topic. Please ask questions. This is like the traditional request, but really, please do. Because from my experience, it is always so that we could lecture, have a good lecture, but everybody is sleeping on the other side of the screens. So if you ask questions, we could touch those questions which are more of your interest. Sorry, that was first question. Anyway, from my part, you can both type or ask questions, but I would be happy also to discuss them. right away. Okay, let's start with the first topic, which is IP. IP, yes. For most of the startups, intellectual property as a topic is probably not on the top of mind when companies started, or not the company. When the idea appears, either you start coding or selling something. Intellectual property, and especially protection of intellectual property, is not on top of the mind, as are probably not the legal issues at all. But at some stage, both the legal matters and especially intellectual property becomes absolutely crucial. And today we will just speak about this moment. And one of the really important items is for you to understand or guess when this point is, when you have to take care of not just IP, but all the legal matters. But let's start from very beginning. What is IP? It could be very simple answer that intellectual property is basically any creation of mind. Or it could be a bit more advanced answer that this is creation of mind that could be commercialized or is in some relation to business. And the answer probably would very much depend on the context and on the purpose of the question. But today we will focus on the second answer, which is more appropriate for legal and business purposes, because any business nowadays, almost any business has some intellectual property. It could be more, it could be less. Some might say that, for example, if you develop real estate or do a construction works, there is no much intellectual property, and to some extent you will be correct. There would be probably less intellectual property involved than in IT business, but at the same time, even the domain name is intellectual property, or how do you use your web page? This is intellectual property. Or if you're doing construction works, if you invent the way how to drive the screw a bit faster than your competitor, you have reached quite an advancement. So this is also why intellectual property is so important. Most of it, if not all, gives the business competitive advantage over your competitors. So this is the edge you can sell. So either this makes your work more efficient, or more beautiful, or whatever. But this could attract more clients, or this could be value to sell. Therefore, this is why, in simple words, why intellectual property is so important. Before we turn to next slide for types of intellectual property, are there any comments, questions? Maybe someone disagrees with what was said here. Okay, let's continue. Types of intellectual property. Most of the answer to E. Mezulis is yes, trademark or patent is intellectual property.
May I also ask a question?
Yes, sure.
So you're saying that the processes and the business processes it's also intellectual property. But if we do the intellectual property paper, it would be no sense because the person can change just a little bit, and the whole process will be no need in this no need in this paper, basically.
Sorry, what do you mean by paper here?
Paper that gives you the right for intellectual property. I forgot the name, sorry, English.
You mean
all
patent?
Right. Well, I come back to, yeah, the patent, right?
Yeah. Okay. I think we will touch this a bit further, but yes, also the business process can be intellectual property, and the question is how to protect it. But that will be next slide.
Okay, thanks.
But anyway, so these here listed, I have listed the main intellectual property types. First of all, copyright. Copyright covers such types of work as books, paintings, software code. So anything which is in these kind of forms. And why these it is important to divide in between those types, because as you will see in the next slide, each of the intellectual property type will have a different way how to protect. So next is patents. Patents covers mostly the technical inventions. It could be all kind of physics, chemistry, and so on. But the patents, if they are registered, they have to be very precise, and they have to reveal all the details of particular invention. That is both plus and minus, because this is very specifically can be protected, the process or the gadget or whatever invention. But at the same time, to protect it, this has to be revealed and published, so everybody can obtain this information, what exactly is protected. Trademarks. Trademarks is probably one of the most popular and easy IP type. This is basically your name, your logo, like that. Industrial designs, very similar to trademarks, but this more relates to forms, packaging, and similar. Geographical indications is a bit off the traditional IP definition. This is something which is related to particular geographical region. Probably the most common example is Champagne or Cognac or Parmigiano. These are not trademarks. These are just the products which are related to particular region. And even if you did exactly the same product elsewhere, you couldn't use this geographical indication. And finally, this is trade secrets. Trade secrets is can be basically anything, and what is important to business of a particular company. This could be method, this could be know-how, basically any process could be a trade secret. The real difference is that trade secrets as such cannot be anywhere registered, and therefore they would not be protected by that. Let me see. Okay, let's turn to next. Next slide is protection of intellectual property, and this is probably the most important slide of my presentation, because it is very important to understand that each of these intellectual property items shall be protected in different way. And unfortunately, there is no common way how to protect them all over the globe. In each country, it could also be different. But there are some general principles which we could follow, and which will most of the cases will be correct. So first of all, procedure for registering and keeping alive. This relates to trademarks, designs, and patents. Any company can register its trademark, but on top of that, depending on the jurisdiction, it should be first, it should be used to keep it live, and second, it should be re-registered every, well, the most common is 10 years. Common term is 10 years, but it could be different. By registering, the company receives exclusive rights to use particular sign or particular name. In some cases, even color or smell as its trademark, and use it exclusively for particular goods. The same applies to the designs, at least in Europe. In other jurisdictions, it could be a bit different. And the general principle of registration is very similar also for patents, but registration of patent is much more cumbersome, because as I mentioned just a few minutes back, it shall include very detailed technical information on particular invention, whatever it be. And what is very important, it is impossible to patent just idea. It should be very detailed product or process. Only that could be patented. And there are patents all around us. For example, I have read, haven't counted, but I have read that just in this iPhone there are like more than several hundred patents inside. And they are they are not just Apple, but very different owners of the patent for that. Next procedure is publishing. Publishing or making public relates to such intellectual property objects as copyrighted objects. For example, the book, the novel, is protected from the moment when it is made public by publishing. The same applies also to piece of art or other copyrighted object. There is always the question about what to do with the software code, because in principle this is also protected by copyright, but it is on the edge of being registered. But in any event, at least in EU space, you cannot register the software code as to protect it. This is again just a copyrighted object. I'm not expert in US law, but they say there are options how to register it in US. Then the next procedure is protection granted by law, and this in this case it covers the geographic indications. I will not go much into details, but for every this geographical indication, there is either specific law, or nowadays this is on EU level, certain rules which can or cannot be used for particular geographic indications. And finally, the last important procedure is just keep it secret. And this mainly relates to trade secrets or other information which cannot be protected in any other way. And again, here is probably the world's most popular example is a recipe of Coca-Cola. Recipe has not been registered anywhere. It is kept secret under in the big safe box under I don't know how many locks, and only the joint management of Coca-Cola jointly can access this this recipe. At the same time, of course, Coca-Cola is one who uses intellectual property very widely, and on top of keeping the recipe secret, they have protected all other IP. For example, the trademark of Coca-Cola is probably one of the most valuable trademarks in the world. The same relates also to Coca-Cola bottles, and I imagine also other items. Any questions up to this moment? So I see that. Yes.
Yeah, there are a few written questions. I don't know whether you see.
Yeah. I just opened the chat window. First, I think I answered about trademark and patent. The second is what can be done when someone is using my business idea after we talk about it, or pitch deck sent. Well, as I said, unfortunately, if this is just idea, this cannot be protected in a legal way. At the same time, especially for the young businesses, it all is about execution. So this depends how one can execute or another can execute. Maybe the same idea could be executed in several ways, but from what I see, in most cases, even the idea is the brilliant, the execution plays so big role that it's almost impossible to copy it. So, but from legal point of view, unfortunately, we cannot exclude these situations. So next question is, can I use SSCom advertisements for deep learning? This is very good question, and this might need some more information and some more analysis how this is done. Because there are specific rules on protection of databases as well, and if in this case SS data can be considered as database, then some restrictions might apply there. Next question: are translations considered intellectual property? For example, if freelance translates a text for a company and translation is part of product, is the translator eligible to claim his rights at later point? So first, yes, translation is intellectual property. Translation would be covered by copyright as similar works. If this is part of leaflet or something like that for product, in most cases, I would say that that at least the reasonable companies would always request the translator to deliver the intellectual property, the copyright of the translation to the company who has the product. If it is not done, there could be discussion or dispute about who has the rights to the translation. Would you kindly explain what geographic indication is? Could you please provide some examples? I think I just did, but in general, this is a product which is mainly products. I cannot even imagine the services, but maybe there are some services also who are related to particular geographical point, but mainly products which are very much related to particular territory. And as I mentioned, the champagne is probably the easiest example, but there are more. Next question is, what about NDA to protect pitch if pitching to the group where signing NDA is possible? Do I understand correct that the person who asked the question wants to ask the audience to sign NDA? Okay. If this is well, in theory, it is possible. It depends on of course on what are those people, what is the amount, what is the audience. But in theory, it's possible. On this, from time to time, this is done before investments, for example, on one-to-one negotiations, before the particular company reveals its intellectual property, mainly in this case, speaking about confidential information, trade secrets, and know-how. In such cases, it is quite often that NDAs are signed. Next question is, can I use trademark as intent for logo registration before I even registered? And does this protect? Well, the logo can be used with or without registration. And just the registration doesn't give the rights. In all cases, it should be a registration plus use or just use. What is the difference? The difference is that if you use your logo, but at the same time someone else registers that the same logo and starts using it, he might legally steal it from you. Unless you can provide that your logo is so widely popular that every reasonable person would anyway associate this logo just with your company. This again could be probably in case of Coca-Cola's trademark. So if for example I register Coca-Cola's trademark in faraway country which doesn't doesn't have this registration, then but has reasonable legislation there, I'm afraid I might lose that registration later in favor of Coca-Cola, because this could be so widely popular trademark that this is enough even without registration. But registration gives this additional layer of security that someone else would not steal your logo or your business name, especially until you are like very popular and global company. When startup should register logo as soon as possible? Well, I would say that the good moment of registration of logo and in general starting to care very seriously about intellectual property is at the latest when you have some sales. Before that, it would be important to take care of copyrighted items. For example, if your startup has I don't know, 3 or 5 software engineers who are working on your brilliant idea, it would be very important from very beginning to have proper agreements that that all what is created during the employment is property of the company. This would be very important to do it from very beginning. But as to the registration of logo or trademarks, this could be a step later. I would say that it could wait until you start sales. But if you do it earlier, even better. So I have run out of questions at this moment. And I think I have one more slide, but I have also a bit exceeded my my time slot. Therefore, I will be very quick. Final slide is about commercialization and transfer. First of all, the using of IP as like in everyday life, this is the basic layer. You can, as any property, you can loan it, sell it, acquire new one. just be sure that this is properly registered. If, for example, you acquire new trademark, change the owners in all the registries. If you acquire new domain, be sure that it is also registered properly. But the next level, which is probably more difficult, but also at some stage might be very necessary, is licensing. Licensing is like natural part of all the IP matters, because the party who owns the IP most likely will be willing to profit on that, because, well, quite a lot of work is done to create it. So the licensing means loaning it or letting it use for some remuneration. The question is, what are licensing terms? Whether it's exclusive license, whether it's non-exclusive license, whether it covers particular territory, or it's global. Whether the licensee has sub-licensing rights or rights to extend the product, to improve it, and how it is commercialized. The same, of course, would work also the other way around. If you are not the licensor but the licensee, you may use other person's IP under the license agreement. Of course, you can also buy the IP, but sometimes it's it's easier and also less expensive to just license it and start using it under license. So this is food for thoughts, and at some stage you might need this. On that note, I will stop on intellectual property, and the last time ask whether there are any questions. I understand that there are none, so I will give the control and floor to my colleague Toms, going on some very serious matters. Thank you.
Thank you, Indriķis. So hello, everybody. My name is Toms Šulmanis. I'm also a partner at Cobalt Law Office. I'm mostly involved in employment and corporate practices, and today I will tell you about 3 topics. So let's start with the choosing of corporate form. So actually, yes, we have just one slide here. And to be honest, it's pretty simple and straightforward. So in Latvia, you actually have only one real and viable option. So if you have decided to set up a company, the only real option is a limited liability company, or SIA. So because first of all, you have very flexible management structure. It can be very simple, it can be complicated if necessary. Secondly, it has very low share capital requirements. So initially you can even just set up the company with €1 share capital. And what Sandhya will tell in the further section about taxes. So as of this year, it's possible to grant share options to employees with tax exemption, which is very important for some startups. And actually, most importantly, is the limited liability aspect of the SIA company. So what it means essentially is that you are not responsible for the liabilities of the company, and vice versa. The company is not responsible for obligations of the shareholders. And this is very essential because, of course, worst come to worst, if something happens to the business and doesn't go so well, so it can be officially filed for insolvency, and you would be protected as a private individual. Nobody can go after your private assets. They would be fully protected with some very limited exceptions. So the only other real alternative is a joint stock company, but that could only be considered if you have some immediate plans of going public to be listed on a stock exchange. But for startups, at least initially, it's still quite a long way to go until public listing. So yeah, if we're talking about Latvia, the only real option is a limited liability company, or SIA. So are there any questions on this section? Unfortunately, I don't, I see the chat. Okay. I don't see any questions in the chat. Okay, so let's move forward. So next we come to the topic shareholder agreements. So of course, if you set up a company where there is just one shareholder, this is really not an issue, but shareholder agreements become relevant when there are more than one shareholders in the company. So why are those shareholders agreements needed? So we hear about them quite often, but sometimes people don't understand why are they actually necessary. So first of all, every company has a document called Articles of Association, or Charter. But this document only provides very basic information about the company, like the size of the share capital, number of board members, and probably some other technical details. But if you have more than one shareholder, and especially in situations where the shareholding is 50-50 or similar, then a shareholder agreement becomes quite essential. Because along the way, shareholders might get into disputes. There could be discussions about selling of shares, and it's very advisable to have this document so that you have some framework how to deal with these issues. So let's go over a couple of items that are traditionally included in shareholder agreements. So first of all, it's veto rights on certain issues. So for example, if you have a minority shareholder holding just 15%, so according to the law, they could not object to any decisions made by a majority, but you can decide that for certain matters, very important ones, this minority shareholder has veto rights. But then the next item would be special rules in case of deadlock situations. So let's imagine you and your partner have established a company with a 50-50 shareholding, and you have to decide on some issue for example, changes in the board or approval of, you have some disagreement and you simply cannot make the decision, and basically the operations of the company are frozen. You cannot go forward. So what to do in those situations? So there are special mechanisms how to resolve those deadlock situations. None of them are very simple and easy on the shareholders. Usually they are related to some mechanism how one shareholder buys out the other one or is forced to do so. And some other issues to be included are procedure for election of management or supervisory board members. And what is very common in shareholder agreements is provisions on sale of shares. So these would be usually drag along and tag along rights. So these are very commonly used terms in investment circles. So what drag along means is that, for example, you have a 70% or 60% shareholding in the company. You find an investor who is ready to buy 100% of shares. So he says to you, yes, I'm ready to buy, but only 100%. So what drag along means is that you can basically literally drag along the minority shareholder and demand that such minority shareholder sells its shares to the same investor on the same terms and conditions. And tag along just works the other way around. So if you are a minority shareholder and see that the majority is selling their shares, so you have a right to kind of tag along and you have a right to demand that this investor buys your shares on the same terms and conditions as the majority shareholder. And there are various mechanisms called call put options. So what this means is that under some circumstances, you as a shareholder can have a right to buy the other shareholder's shares, or you can force the other shareholder to buy your shares, which is a put option. So it could work in case of deadlock situations. It could work, for example, in case an investor makes a special agreement that if during some time period the financial conditions of the company are not so good, so they have a put option, they can sell their shares to the other shareholders for some fixed price. Some shareholder agreements where the investors are doing the investment and then they want some special treatment for them to be granted. So such special treatment can take the form of, for example, liquidation preference, which means that if the company is liquidated and they have a certain amount of money which they can recover before all shareholders, or quite an interesting mechanism called reverse vesting for founders. So what it essentially means is that, for example, there would be a 2-year reverse vesting period for founders, meaning that you would kind of earn back your shares. For example, if you leave during the first month after making the agreement, you would basically lose all your shares. And if you leave the company at the end of this 2-year period or close to it, then you just lose a small portion of the shares. So this is sometimes what investors request to ensure that the founders are staying with the company and make their contribution and don't just go away on the next day after the investment. So we have a question. What is the main difference between SIA and biedrība? So basically, biedrība is, or an association in English, so it's a non-profit organization which cannot engage in any commercial activity. It's only for non-profit purposes, and you can only work on those goals which are set in the articles of association. You cannot sell anything, basically. If a company conducts some portion of non-profit activity mixed with profit, should it be biedrība instead of SIA? No, it's actually the other way around. So if it does some work for profit, then it should be SIA, and engage in some non-profit activity.
Toms, maybe I can also shortly jump in and try to comment this from tax perspective. Those associations, they are not taxpayers because they, as Toms correctly noted, that they are intended not to work with the purpose to get the profit and then distribute it to shareholders. So, but at the same time, of course, there might be situations that there is an association and the profit of this aim of this association is not to generate profit for the owners or shareholders, but that it engages in some transactions which are basically for consideration. For example, association can own real estate, but it has historically, for example, building. For its non-profit activities, it needs only a small part of this building to have some office, but then the rest is leased out. And that would be kind of action for consideration. They would collect lease payments, but the main purpose or main difference here would be that those lease payments collected, they cannot be used to distribute that as a profit to owners or shareholders, or basically members of this association. This collected rent must be then used to achieve those non-profit goals which are set by the association. And in fact, this might be very complicated topic from tax perspective, because of course tax authority might not really like association which is not paying taxes, but which is carrying out some business or transactions. And therefore, if possible, I would always suggest to split those activities for business operations, for profit operations, to use SIA, this limited liability company, and then association would basically leave just for those non-profit activities, because sometimes it might be kind of difficult to make sure that those transactions which are made by association then do not trigger some investigations by the tax authority. Yeah, Toms, go on. There are some other questions. Yeah.
Yeah. So the next question is it written in the law that a shareholder with less than 15% cannot affect the company's work decisions and so on? Yes, that's true. So there are basically two thresholds in the law. So for basic decisions, it's 50%. So with simple majority, you can adopt such decisions as changes in the board. There is the second threshold of 2/3 majority. which is for important decisions such as reorganization of the company, liquidation of the company, changes in the share capital, and articles of association. But if you are under those 33%, then basically, unless there is a special agreement, then you cannot basically affect any operations of the company. That's true. Okay, so I think we can move to the Okay. So employee stock options. So as you probably have heard, there are a number of recent surveys where it's clearly shown that especially the younger generation is no longer motivated just by salary. So there are various other factors affecting their motivation, like working environment, ability to contribute, teamwork, and such non-material issues. And being a shareholder, even in a minor part of the company, so it's kind of a next level motivation. If you know that you are an owner, so in some cases it might work as a really good motivation for the employee. And especially in case of startups, so probably at the very initial stage, will not be able to pay very high salaries to employees. So employee stock options is kind of how to give this additional motivation and prospects for employees that they have a feeling that maybe after a couple of years some large investor will come, buy out all the shares, and then some good money. So essentially, what is a share option? So basically, it's a right to acquire a certain amount of company shares during a certain time period, and for a predetermined price, which can be also zero, it can be nominal value of the shares, or higher if so decided. So it's also important to remember that it's not possible to sell or otherwise transfer share options. They are personally to the specific employee to whom the options are granted. And also during the time period, which they are still options and not real shares, so they don't give any actual rights to the option holders, so they cannot get any dividends vote in the general meeting. So to understand better how share options work, I have put here a picture of a typical vesting schedule with 1-year cliff. So vesting is a term you should learn very well if you're interested into share options. It's very widely used by investment funds and angels and whatnot. So basically what vesting means is that you are acquiring a certain number of shares according to a schedule. So if we look at this graph, we have a 1-year cliff which means that during the first year, you are not getting any shares at all. And once you are past this 1-year cliff, you are immediately getting 25% of the shares assigned to you. And then during the next 3 years of the vesting period, you would get the remaining 70%, 75% of the shares. So that is actually quite typical schedule. It's very common to have a 1-year vesting cliff and 3 or 4 years total vesting period. Okay, so if you decided to issue share options, so what are the main issues to consider? So first of all, one good thing is that for joint stock companies or AS, there is a limit of 10% share options from the share capital. So no more than that for joint stock companies, but for limited liability companies, there is no such limitation. So we have seen in practice that, for example, even 49% of shares are distributed to board members or employees as share options. So first of all, the decision should be made by the shareholders meeting to approve the share option plan, and also the main document, which is the share option agreement. So the share option agreement basically contains all the essential conditions which will be applicable for the particular employee. And there will be separate share option agreements signed with each of the employees who are entitled to get the options. So here I have listed some of the main issues which you should consider when drafting the share option agreement or considering what to include there. So first of all, what we already talked about is this vesting cliff and vesting period. So usually it's 1 year for the vesting cliff. You will learn in the next section of Sunday why it's 1 year. It can be very different. It can be even just this 1 year, so you get all the shares after the vesting cliff. It can be 5 or 6 years, whatever you decide. The option to consider is making the grant of shares subject to fulfillment of certain KPIs. So, for example, an employee would automatically get 20% of shares after the vesting cliff. But if the employee has fulfilled the KPIs, then he would get additional 5 or 10%. And this can be also relevant during the whole vesting schedule. So each year it can be evaluated. For example, if the annual KPIs have been fulfilled, then the shares are granted or not granted. Then you should decide how frequently you will exchange the options for shares. So usually, due to some practical reasons, it's once per year. Theoretically, it can be done more frequently, but it's just too cumbersome from corporate side and too much paperwork. So usually it's just once per year. Then what we already discussed for shareholder agreements, you should also consider including certain provisions regarding sale of shares. So, for example, you have 20 employees with small numbers of shares, but in most situations, the investor wants to buy 100% of the company. So here you would also include the said drag along clause. So you would say that if the majority shareholder sells the shares, then you can sort of drag along the minority shareholders, the employees, and so that the investor can get all 100% of the company. Next very important condition to consider is the so-called good leaver, bad leaver situations. So obviously you should have different solutions depending on whether decided to terminate the employee as a company, for example, decided to discontinue some part of operations and no longer the services of some employees are no longer necessary. So this would be a typical good leaver scenario. And in that case, you would either let the employees keep the shares or buy the shares back for a certain amount, which could be close to the market price. If the employee is a bad leaver, for example, you have terminated him or her due to some violations, then the scenario could be that you are buying back the shares just for the nominal value, or even they have to give it away without any compensation. Then another thing to consider is accelerated vesting. So let's say you have a vesting schedule of 4 years. But let's say after 2.5 years, some investor comes and wants to buy the shares for some attractive price. So you can have a provision saying that in that case, all the invested shares according to the schedule would vest immediately. So this would be kind of additional motivation for employees so that they can see that if there will be an exit by the majority shareholders sooner, then they get all of their shares according to the option scheme. So in that case, they would simply get higher profits. Then one technical issue to consider, so once you have signed the first option agreement, then the management board of the company must create and maintain the so-called option holders register. There are no specific requirements under the law. It can also be some Excel table. The main thing is that you have all the information there. Once the next option agreement is signed, you immediately enter the data, and company shareholders, option holders, board members, and competent authorities have the right to access that option holders register. Then important topic, which actually makes a lot of those things which I discussed possible. So these are share categories which have been introduced for SIA companies just from the beginning of this year. So before that, limited liability companies could have only one category of shares. So if you issue employee share options once they acquire the actual shares, so they would have exactly the same shares as all the other majority shareholders. But as we discussed before, there are certain limitations which you might want to include. Shares to be granted to the employees. So, and that is all possible due to this new concept introduced at the beginning of this year. So what you can actually do here. So you can grant employees different rights for the main three areas. So first of all, it's the right to receive dividends, the rights to vote in the shareholders meeting, and the rights to receive liquidation quota. The only rights you can include, contrast to joint stock companies, you can include various other rights in the share category, like the already mentioned tag-along, drag-along rights. For example, restrictions on sale of shares, restrictions on pledging of shares. So there are really a lot of options what you can do here. Then if we talk about the nominal value of shares, so before 21, it was possible only to have €1 as the minimum share value. But now, since the introduction of share categories, it's also possible to have 1 cent as the nominal value of shares. So in most cases, actually, that's what we recommend. We recommend to use this 1 cent as the nominal value of shares, so that you have more flexibility of granting the shares to employees. So for example, if you have a share capital of €3,000, be possible to grant some 0.05% shares to the employees. So this 1 cent gives this opportunity. And what you should also remember is that these share categories can be used not only for employee shares, but they can also be used for structuring investment deals. So, for example, an investor will come and want to invest in your startup. So the investor to get some different category shares with some special rights. So partially we already covered these issues. So yes, let's just quickly go over what are the actual rights that the employee will get once he or she will acquire the shares. So the first three basic ones, what I already mentioned, the voting, dividends, and liquidation quota. So some of them I already mentioned. The other ones are waiver of first refusal rights, which basically means that if some other shareholders will sell their shares, then according to the law, every shareholder has first refusal rights, which means that they have a right to buy shares at the same price. But want to provide that there are no such rights for employees if some majority decides to sell. This is what you would include in the special employee share category, and same with the possibility to acquire new shares in case of capital increase. So this can also be limited in case of employee shares. Then one very peculiar topic to discuss is the shareholders' rights to information. So basically, these are rights which are provided in the commercial law, and you cannot really cancel them even by this special employee share category. So what it basically means is that any shareholder of a limited liability company, even just with 0.1% of shares, they can basically submit a request to the company's board to provide any information and documents on operations of the company. So very theoretically, an employee could ask copies of all other contracts, for example. Yeah, these rights can be limited, but it's quite a burdensome procedure. You have to summon shareholders meeting and provide some motivation why those rights are limited and why giving of such information could cause substantial damage to the company. So of course it's possible to limit them, but you can imagine what that could be a problem if each and every employee starts to ask information from the company's board, and you have to deal with those requests on a weekly or monthly basis. So unfortunately, that's how it is. These rights are simply there, but the good thing is that most employees are not aware of them. They are very eager to cause some problems, so you wouldn't be running into these issues normally. Then one technical issue. So there, along with the adoption of this possibility to issue various share categories, there were also changes in the law allowing the company to hold its own shares for the purposes of granting to the employees or board members. Also an exemption that you can hold those companies' own shares for unlimited duration, in contrast to other cases where the maximum period is 1 year. So, for example, you can set up the share option plan where 5% of company shares will be granted to employees, and during the whole vesting period, those 5% are held by the company itself. Then we come to the last topic. So how you can actually grant those shares to the employees. So let's say that you have this 1 year vesting cliff. And time has come, you need to give actual shares to the company. First option is what was discussed in the last slide. So you can, the existing shareholders can transfer their shares to the company, and which in turn gives away the shares to the option holders. Then another option is that you simply perform a usual capital increase, simply pay the nominal value or some higher amount and get those shares according to this share capital increase. Other option is that you can the existing company to employees' shares. So that's in case if you have a profit to convert, that's also a good option. So employees don't have to pay anything by themselves. You simply use the profit and create the employees' shares. Yes, so this is the end of my topic. Let's see if we have questions. Yeah, so we have one question. Have you had any experience with dynamic equity between founders? Probably, Gatis, you could explain what you mean with dynamic equity. To be honest, I haven't had such experience.
I was thinking about when a startup doesn't have any money, so the founders agree to give shares of the company according to the time they have given to the startup. So it becomes such kind of dynamic equity distribution system where equity is distributed like in according to the time they put in the startup. I know that in Latvia I haven't had any experience in legal experience with this. So for now we're just working like with a handshake. So I was just wondering if is there any legal way how to write down this how to say like dynamic equity.
If you have interest in this topic, we can have probably discussion after details how it could be implemented. I don't have a ready-made answer. I haven't seen any such dynamic equity schemes here in Latvia implemented.
Yes, thanks.
So yeah, if there are no more questions, so I give the floor to next speaker, who is Sandhya Novicka on tax aspects.
Yeah, good evening, everyone. So my name is Sandhya Novicka. I'm a partner at Cobalt, and my specialization is related to taxation. And today, we also wanted to share some core information about tax aspects that basically you must take into account when you set up those employee stock option programs to be sure that basically you do this in a maximum so to say neutral way from tax perspective. And you may know that in Latvia now, basically as of the beginning of this year, we have really good tax regime as concerns those share options. So basically it is possible via this employee share option program to give to employees shares in the company without paying payroll tax, namely without paying personal income tax and social tax that are normally payable basically for any fringe benefits that the company provides to employees. In order to benefit from this tax exemption, there are certain criteria or conditions that have to be complied with, and which are kind of pretty important, and Latvian Tax Authority really closely monitors and checks whether all those tiny things are in place and everything is in compliance with the personal income tax law. So if we go through those formalities, then one of the things is that those shares are provided, or options initially are provided by the employer or a related company of the employer in accordance with the option plan. That's kind of one of those formal documents that you need to have in place, where basically you describe those main terms and conditions under which options are provided to employees and how those options can be exercised afterwards. The other thing is a minimum holding period is 12 months, and this is so-called vesting cliff. as Toms mentioned, now it's very often 1 year. Basically, from tax perspective, it is not advisable to use a shorter period, because if this vesting cliff is let's say within 6 months from the grant of the options, so 8 months from the date of the grant, and then employee exercises these options, then a payroll tax must be paid, and we will discuss it afterwards. So this minimum holding period, 12 months. And during this minimum period, employment relations must be maintained either with the company that provided, like this initial employer, or with another company within the same group. So you can change employment within a group, but if you leave the company and the group before those 12 months, then basically this tax exemption cannot be used, and normally also basically company has no interest to keep or leave those options to employee, which is going away for one or the other reason. Then a very important condition is notification provided to the Latvian tax authority. So basically, when you have this option plan ready, you have signed agreements with the employees regarding those options, then within 2 months, company, like employer, must provide information to the tax authority in which company describes in detail this program, provides information regarding employees to whom those options are provided, and also describes terms and conditions under which those options can be exercised. Then it is also important to keep in mind that, let's say that this vesting cliff is correctly set, it has passed, also this vesting schedule is in place, and shares options have vested, and employee can already exercise those shares. Then it is important to do that while employee is still in the employment relations with the company, or not later than within 6 months after the termination of the employment relations. Let's say if the employee leaves the company before exercise, and then, I don't know, either investor comes and there is a good possibility to kind of sell the shares, and then employee decides to exercise those options and acquire the shares in order to sell them to the investor. But if that happens, let's say after a year, the employee left the company, then again, this tax exemption will not be available. So this is something, again, important to keep in mind. And then there is another formal criteria that upon the moment when the options are exercised, there cannot be outstanding loan issued by the employer or related person to the employee. And the only exception is in respect of this condition is available to banks and other licensed creditors. So yeah, it's just important not to miss also this condition, just in case sometimes employee needs some short-term loan for totally different purposes, and this can create problems. So what is stock or share? The good thing as of the beginning of this year is that now options can be issued also by limited liability companies, because until beginning of this year it was not possible, and that created kind of quite a big problems, because as Toms at the beginning indicated, basically absolute majority of the companies which are incorporated in Latvia, they are in the form of limited liability companies, and due to this, basically, options were mainly issued by companies like parent companies incorporated either in United Kingdom or United States, but here in Latvia, at the level of Latvian companies, this was a kind of a not so often used instrument. Now it's possible, and we see that more and more companies are using this tool to motivate employees. If your company is part of a bigger international group, and if those share option plans are prepared in United States or United Kingdom, then sometimes in those option programs you can see also other instruments like restricted stock units or restricted stock award, and then it is crucial to understand what does it mean and what kind of rights employees acquire under those instruments. In general, this tax exemption is available also in respect of those instruments, but it is important to make sure that under those instruments, employees do not acquire any rights of the shareholder within this minimum holding period, namely this 1 year. For example, if there is this restricted stock award, it is quite often that under US laws during this first year, employee cannot use voting rights, employee cannot sell those shares or pledge those shares, but employee already immediately is entitled to receive dividends. And then basically it means that that this one of those criteria, namely this holding period, that it's not met, and basically in such situations this program would not qualify for the payroll tax exemption here in Latvia. So this is something to take into account if basically this option program is created somewhere abroad. There must be someone who basically checks terms and conditions of this program to make sure that it complies with the tax requirements here in Latvia. And if it does not, then basically you need to introduce some special conditions in respect of the employees here in Latvia. It doesn't mean that it will not work at all, but just simply make sure that some special conditions are inserted in this program in respect of Latvian employees. Holding period, I think we discussed the main thing or basically content of this condition. It is possible to set also longer period, like longer vesting schedule, as Toms described. Quite typically, it is that this vesting cliff is after 1 year, but the total vesting schedule is for 4 years, because of course the company is interested in basically keeping this employee within the company and making sure that the employee stays in company and continues his or her work for the company and gets those shares only gradually. In such situation, I would say it is important in this option plan or also in option agreement to make sure that it is possible for the company and employee to agree that those options can be exercised also earlier. Let's say in 2 years, like a company grows and unexpectedly, but after, let's say, 2 or 3 years, there is a good investor and it's a good time to sell the shares, that then company and employee can basically agree that the remaining options can be exercised earlier. Why it is important? It is important to avoid unnecessary discussions with the tax authority, whether in that case tax is payable or not for those options which are exercised earlier than this initial vesting schedule. About employment relations during this minimum holding period we discussed, and also about those 6 months we discussed. Then the next is this notification to the State Revenue Service. So this is a critical thing. We know some companies who have introduced those share option plans, have granted options, but who have missed this requirement to notify Latvian tax authority. And unfortunately, Latvian tax authority is very strict. They are not accepting some sort of retrospective or delayed notifications. They are not accepting any evidence that those options were granted before a year or 3 years. Basically, if you have this type of situation, you have two options. Either you must pay payroll tax because exemption cannot be used, or you have to start the whole program from the very beginning, which means you must set new minimum holding period, and only after this 1 year you can provide shares to employees without paying payroll tax. So this is important. It is important also to keep in mind that if during the term of this employee share option program you introduce some sort of amendments, then basically, first of all, of course, you need to check whether those amendments are in line with the requirements set in the personal income tax law. And second, you should check which amendments must be notified to the tax authority. And again, those 2 months must be complied with in order to make sure that this tax exemption can be used. Also, if, for example, new employee joins the company and this employee works, let's say for 6 months for the company, and then you see, okay, this is a good employee and I want to provide options also to this employee. So this type of amendment or addition to initial share option plan also must be notified to the tax authority within those 2 months from the moment you provide options to this new employee. What we hear in questions from our clients in respect of this notification is whether when the tax authority will receive this notification, whether it will immediately kind of review this plan and therefore either confirm that yes, this is good employee share program or plan, or this is not good and you cannot hope that you will be able to use this tax exemption. That's not the case. When you submit this notification to the tax authority, basically you just receive answer, thanks, your information is well received, and that's it. So it means that the tax authority will start to investigate or review this information only once it will have some indications that there is something wrong with this program, with those options or shares. And most probably this will happen only sometime after the exercise of the options, when the employee will suddenly get thousands of euros or even more for the shares. Then the tax authority might start read those documents and send in questions if they have some suspicions regarding compliance with the set requirements. And then like to give you some feeling like how important is this tax exemption and what kind of tax burden is on a company if this tax exemption is not available because you do not meet those statutory requirements set in the personal income tax law. So, you know, those tax rates, personal income tax rates and social tax rates that the employer must pay for a salary or any other employment-related income. So those tax rates apply also to income from basically those options unless exemption is available. And how you determine this income in case of those share options? So basically you take market value of the shares at the moment when the option is exercised, minus acquisition costs of the shares. And acquisition costs of the shares, it's sometimes called exercise price or strike price. Under Latvian law, basically, it is possible that the employee basically pays nothing, and those acquisition costs are zero. But in United States, for example, there are kind of certain rules which basically define what is this exercise or strike price which must be paid by the employees at the moment they exercise this option and get shares. And so here is an example that let's say the employee pays this exercise price, strike price, €1 per share, which is nominal value for the share, and acquires 100 shares. But the market value at the moment of exercise of those options is €100. And so you see that the income of the employee in such situation is 9,900 euros. And that's basically the net income that employee basically gets in his property. And therefore, from this net profit or net income, employer must on top calculate personal income tax and social tax. And roughly, basically, this tax burden on employer is very close to this net income of the employee from the exercise of option. So it's approximately 8,000 euros. So this just indicates that it is really important to ensure that this share program meets all the set requirements in order to be eligible for this tax exemption. If the tax exemption is applicable, is available, so the company has ensured that all conditions are fulfilled, then at the moment when option is exercised and the employee acquires share, no tax is payable. So at that moment, no taxation occurs. And basically the only thing which employer must keep in mind is that also in this case, this income of the employee must be notified to the tax authority as non-taxable income. And so what happens further? The employee has exercised option and now has certain amount of shares, and sooner or later employee decides to sell those shares. And at that moment, basically the question is whether there will be capital gain or not, and the employee himself or herself will have to pay personal income tax or capital gains tax. And there we have to basically separate those two scenarios depending on whether tax exemption was available or was not available at the moment when the options were exercised. And let's start with the scenario where for some reason this tax exemption or relief was not available, was not applicable because some of the conditions were not fulfilled, which means that at the moment of exercise, employer already paid payroll tax. And so we now have to determine what is the capital gain and tax payable by the employee from this capital gain. So how do we determine it? We look at the sales price at which employee sells those shares to somebody in the market or investor, and we deduct market value of the shares upon exercise, because that is the value from which employer already paid tax. And here you have also brief example how this tax is calculated. And so you can see that this example where market value of the shares increases by 50 euro per 2 years, then employee would have to pay personal income tax in the amount of 1,000 euros, because basically this gain in such scenario of the employee would be 5,000, and you would calculate capital gains tax at the rate of 20% from this capital gain. A bit different is the situation if this tax exemption was used at the moment when employee exercised options. So as you remember, if this tax exemption is available, then at the moment when options are exercised, no tax is paid, neither by employer nor by the employee. Employee just becomes owner of the shares. And so if we look what happens with the same numbers of shares and say same value of those shares, then we can see that under such scenario, basically this capital gain is bigger because from the sales price at which employee sells those shares, we deduct only those acquisition costs of the shares that the employee had at the moment when he or she exercised option. Normally, that's the kind of total amount of this exercise price or strike price paid by the employee, and therefore, basically, you have bigger amount of this capital gains tax that is payable by the employee. But anyway, if we compare here you have basically almost 3,000 euros payable, while if we look at this scenario where this tax exemption is not available, then you will see that 1,000 is paid by the employee, and in addition to that, 8,000 were paid by employer. So basically, if tax exemption is not available, then this total tax burden is basically almost 3 times or roughly 3 times bigger than in a situation where tax exemption is used. Employee after the sale of the shares basically will have to remember that it's his or her obligation to submit capital gains return and pay this personal income tax. The time when this tax return must be submitted depends on the gain. So it can be either on quarterly basis if the gain exceeds 1,000 euros, or it can be on annual basis if the gain is below 1,000 euros. And here you can see also this form, so it's nothing super complicated. Basically, you just need to fill in those spaces left for those prices at which something is sold and something is acquired, and basically then the system calculates payable tax, and tax returns, of course, should be submitted via electronic declaration system. If the employee has those shares, then another type of income that the employee can receive is, of course, dividends. Not only is this gain from the sale of the shares, and if dividends are distributed by the Latvian company, then basically individual is not obliged to declare such dividends in his or her annual tax returns. This system is this information basically is automatically included in the annual tax return. A bit more complicated is the situation if dividends come from foreign company. Yeah, because if the dividends are received from the Latvian companies, then basically individual has no obligation to pay tax. Tax is paid at the level of company, like corporate income tax, and then basically individual can receive those dividends and do whatever he or she wants with them without paying tax. More complicated is the situation with dividends from foreign company, because then basically you must check or verify whether the company that pays those dividends is corporate income taxpayer in the respective jurisdiction, or if that's not the case, whether income tax is withheld from those dividends abroad. If it is so, then no additional personal income tax is payable in Latvia. In such case, basically, individual must only submit this information in his or her annual return by filling in this information in D2 annex. In practice, individual should be basically ready to demonstrate to the tax authority this information regarding company who distributed those dividends, whether the company is corporate income taxpayer in the respective foreign country, and therefore basically prove that no personal income tax is payable in Latvia. That's actually all from my side. I think in the chat, I do not see any questions, but most probably you should have. I believe this might be quite complicated, but at the same time, just feel free to ask questions, because you can believe me, if you have question, most probably someone else has this question. If no, then I will start slowly transfer the floor and screen to my colleague Gabriela, who will continue with the topic, which is, I would say, maybe even more complicated than taxation, at least for me as a tax person. So it's about personal data, but I'm pretty sure that Gabriela will help you to sort it out and understand what you should do and what you should not do to be in a good shape. Gabriela, I understand you have control already, right?
Yes. I can move. So yes, Sandy pretty much summarized it all. I think we can begin with a quick overview and the basics of privacy and GDPR. I think it's no surprise and no wonder anymore that the data have become one of the main values for many companies and what they operate on. And I think we have all seen the now famous Times cover where they have replaced the oil stations with the data servers. So that is the new reality we have to adapt to, and many companies are struggling because the data protection rules are getting more and more stringent and more, let's say, companies have to pay close attention to how they do their activities to ensure compliance. So the GDPR is a regulation which is adopted on a EU level, and it is directly applicable throughout the member states of the Union. So it is quite handy because you know that generally all of the rules will be similar or the same in all of the countries where you operate in the European Union, and there can be slight deviations based on the local practices. Some of the basic definitions to start us going and to set the scene so that we all understand what I'm talking about is personal data. First of all, is any information that relates to natural person or an identifiable natural person. So it's not just name, surname, personal identity code. In the online environment, it's also IP addresses and information that can deduce you to who the natural person is. So you have to pay close attention to what information you have and whether that is personal data. And the two most important actors with personal data are controller and processor. So controller is the one who determines what personal data, why, how, when, for how long are processed. And processor is the other company or cooperation partner who actually does this on behalf of the controller. Sometimes there are no processors, sometimes there are sub-processors. The allocation of roles can vary, but it's important to know in what capacity you're acting at any stage. And of course, GDPR implementation is something that has to be on top of the business mind and always kept in close sight, because it is not it's not possible to only adopt a privacy notice or privacy policy, publish it on your website and think it's done. With any new activity that you do, with any new data you gather, you have to update it to reflect the actual situation that you do, the data you gather, for how long it's done, and so on. So the main obligations that arise from the GDPR, I have tried to summarize them here, but they are of course not exhaustive, and there can be others, but these are the most popular, and these are the ones we will divulge in today. So we'll talk about the general principles and documentation that has to be implemented. So the general principles, or the core of the regulation, can actually be summarized in the Article 5 of the regulation, and they tell a lot to us about how the data should be collected, processed, and what can we do with them. And so I suggest we go through all of them to give us a feel of how important these requirements are. So data have to be processed lawfully, fairly, and in a transparent manner. That means that you have to have a legal basis for any data processing operation you carry out. So either it is processing on the basis of consent, on the basis of agreement with the data subject, on your legitimate interests, but you have to have it understood. Also, data have to be processed in a transparent manner, meaning that the people whose data you process must understand how, why, and for how long it will be done. The purpose limitation principle means that you have to process data only for such purposes for which you have told the person you will do it. You cannot gather data, for example, we cannot gather data, your email addresses, to organize this webinar, and then on the basis of this, that we know your email address, we will send you direct advertisement. That is a completely different purpose, and that cannot be done with a separate legal ground. Data minimization means that as soon as you have data which you don't need anymore, for example, they are already, let's say, old, or you have you don't carry out the respective activity anymore, you don't need them, these data must be deleted. As also, data must be accurate. So whenever somebody changes their surname can change, their email addresses, their addresses, you can imagine it's a long list. So anything that you keep must be accurate, and the people have also the right to request you to correct inaccuracies. Storage limitation means that you have to know for how long all of the data are kept, retained, and you have to stick to it. So if you set some of the terms may be set in law, for example, accounting documents, there are documents that have to be stored for 10 or 5 years, employment agreements and employee related documents can be stored for 75 or more years now. So depending on the data you gather and collect and store, the rules may differ. For those where the term is not set in law, and if it's not strictly prescribed somewhere else, you can determine the storage limitation for how long you'll keep something yourself. For example, for as long as you need the data, you can keep them. It's not prohibited. But as soon as you don't need them, you have to have clear understanding as to why you're still keeping it, and maybe it's time to delete the data. The data also have to be secure, so you have to ensure the integrity and confidentiality of data. It means depending on the type of processing you carry out, different security solutions and technological solutions should be implemented to ensure that data are secure. And all of these principles, in essence, encompass in the accountability principle, which mean that the controller has to be able to demonstrate compliance with all of these principles and the GDPR in essence. So it means that because of these principles, you have to have these notices, the policies and internal guidelines and instructions, because otherwise nobody actually can take your word for it that, well, yes, of course we delete everything when the time comes. No, you have to have it documented. When will the time come and when will you delete the data? And something I didn't mention earlier, but of course, why companies are so are not reluctant anymore to observe the principles and the obligations is due to the fines the supervisory authorities can impose due to violations of the GDPR. It differs based on the obligations, but the general rule is that the fines can be up to 20 million or 40 million euros. Or it's 2% or 4% of the annual turnover of the whole group of the company. So the fines are huge and the supervisory authorities are not shy to impose them. Latvian authority also has imposed some bigger fines in the amount of 200,000 euros and 150,000 euros, I think. So yes, so it's important to keep everything in good order. The mandatory documents that have to be implemented or introduced are privacy notices to all data subjects, but I will actually talk on that in more detail further. And internal policies or procedures for employees and company. The internal procedures, in essence, mimic the way how the company implements these general principles we just talked about earlier. So the procedures have to allocate the responsibles within the company for the security of data, for the notifications in case of data breach. There has to be a data retention policy, setting time limits for each of the processing activity. There should be a procedure how data breaches are detected and notified to supervisory authorities and data subjects, and so on. So for every obligation, you should have instruction to your employees internally as to how to act in case something happens. And one mistake companies sometimes assume is that if they do not actively process personal data within its operations, or it's not its core business activity, that they do not have to comply with the GDPR, which is actually a wrong assumption, because one of the biggest data that company will process is employee data, and many companies face big fines because they have not been compliant with how they process that. So in respect to employee data, there also have to be all these policies and documents we talk about. So agreements with cooperation partners is data processing agreements, which you have to conclude with other data processors or joint controllers. So we talked about who they are, but in essence, the cooperation can be in 3 or 4 ways. So controller can cooperate with a processor. Controller can cooperate with other joint controllers or separate controllers, and processors cannot cooperate with the other sub-processors. So the most detailed instructions for how to and what has to be included in the agreement is for the most popular one, controller processor roles. So you have to include within the agreement how processor can act, what data they can process, and that they have to ensure confidentiality of the data, that they will make data available for the audits, that what kind of technology and solutions they have to implement to ensure the security of data, and so on. So quite strict rules which have to be included within the agreement, and without them the agreement is not considered valid and compliant, and that in itself can be a violation of the regulation. Also, the regulation prescribes that different kinds of impact assessments should be carried out in different situations. For example, data processing impact assessment is a document that the controller should create when they plan to start an activity, a processing activity, which may result in high risk to data subjects, or which involve new technologies within the processing. So with this document, you should assess whether or not you can proceed with the processing activity. Similarly with the legitimate interest assessment. So if you want to rely on legitimate interests for a processing activity, for example, we wish to send out direct marketing on the basis of legitimate interests and not consent, this is what you have to assess and make a conclusion whether it is even possible, or the intrusion into the privacy of the data subjects is too high and it cannot be continued. No, it cannot be even started, because this is something you do prior. And also one important document which can be hard to keep up with initially, but once you have implemented it, it should be easy to just quickly update it, is records of personal data processing, which in essence we usually see as these huge Excel files which should contain information on all of the data processing activities the company is carrying out. And it relates to all data subjects, all categories of data, all activities. You have to understand where the data go, who you share it with, for how long it's retained, and what kind of technical solutions are implemented to ensure the security of data. So it's kind of a mapping of data, but once you do it, you get a clear sense of where you are as a company, what kind of data you have, and ensuring compliance after creating this document is increasingly more easy. So security of personal data will depend on the activity you conduct and the sphere or area you conduct your business in. Because, for example, in the banking sector or financial sector, there can be specific rules by the respective authority, the FCMC. If you are subject to NIS directive, then different rules may apply there. So it is necessary to understand whether there are some kind of external regulatory framework that will apply apart from the GDPR. And if yes, whether there are some data security specific rules. If not, then you have to assess the inherent risk to the processing activities, how you can keep your data secure with the appropriate technological, organizatory, and other means and tools, and implement the data protection by default and data protection by design in your solutions. So what came as a novelty with the GDPR are the rights awarded to data subjects. So maybe one of the most famous one is the right to be forgotten, which actually cannot be exercised so easily or so often as people might think. So the regulation awards many rights, such as right to access data and have information as to what data the company has about me, and the person is entitled to receive all of it in a portable form. Person can ask to rectify or delete data. A person can ask to object. A person can object to processing. Person can ask to restrict processing, and other rights. So what you must understand is what kind of rights at what situation data subjects can exercise, and whether you should so to say, reject or you will go forward with the request. So for this one, you should also have an internal procedure. But also data subjects have the right to be informed about how their data are processed, and this they have irrespective of whether they have contacted you. So that is partly the reason why, or the main reason why privacy policies are now all over the place. So the GDPR has Article 13 and 14, which quite strictly stipulate what kind of information you have to give to people before they or you start personal data processing. They have to know who is the controller, what kind of data you will process, for how long, who you may transfer it to, whether you transfer it outside of the EU, and so on. If we are talking about employees, it does not have to be included in a separate document. It can be included in, for example, employment agreement, but you have to keep in mind that it is not so to say flexible solution, because privacy policies tend to or they have a need to be updated, and it may not be so easy to update or conclude amendments to the employment agreement. It would be more easy to just update your privacy notice, which is available to all of the employees. So another hot topic, I would say, in the personal data protection field is data transfer outside of the EU. So per se, it is not prohibited, but as of last year's summer, it is becoming increasingly more difficult to transfer data outside of the EU without more obligations. So maybe you have heard, maybe not, but the Court of Justice of the European Union adopted the decision Schrems 2, which invalidated the privacy shield between the EU and the US, which in essence was a mechanism if companies were certified to adhere to these rules under this privacy shield, data could be transferred to US and EU without any other documents or agreements. So now it is not in place, and if you want to transfer data to the US, you have to comply with the any of the mechanism implemented with the regulation. The most popular one is conclusion of standard contractual clauses, which is a document adopted by the European Commission, and in practice is a standard agreement which have to be concluded between the parties and cannot be changed in essence. It can only be supplemented with the peculiarities of your data processing activities. So, but even if you rely on standard contractual clauses, you still have to assess whether the personal data security regulation in this third country, US included, is compatible with the principles and the regulation in the EU. And in many cases, that is not the case. So there can be a risk that data cannot be transferred. So even if there is no strict prohibition to transfer data, the overall feeling within the EU is pro data localization in the European Union. And yes, so you have to be really cautious about how you transfer data outside. So I see we have a question. Where do we find out protocol for our specific industry for data processing security? Is there a central site? Does the information differ much between the EU GDPR and specific rules for Latvia? So the specific industry rules, there's no tool to find them in, so to say, easy way. You have to study the applicable laws and legislation and look for any possible need to implement any technical or organizational measures to ensure data security. And the rules between the EU GDPR and Latvia specifically do not differ in essence, because the GDPR in Latvia is directly applicable, and it is directly applicable in all 27 member states of the EU. So in Latvia, we have this personas datu apstrādes likums, but it does not mirror the GDPR. It only states competencies of the authority and other procedural aspects. So everything you should know about the processing the requirements in itself is within the GDPR. And so finally, finally, one major problem that the companies deal with is ensuring compliance within their web pages. So we have all seen these possibly annoying banners with requests to either accept or deny the use of cookies. But actually, this is the correct way to organize your website. So if you have, if you use cookies, it has to be used on the basis of consent. Only strictly technically necessary cookies can be used on the basis of your legitimate interest to get the site running. everything else, analytical, advertisement, customization, so all these other cookies can be implemented only on the basis of consent. Moreover, consent has to be gradual. So I cannot only accept cookies like in the last example below, there is accept cookies, and I assume it's accept all of them. Yes, so that is not the correct way. You have to have an option to specifically consent to potentially one and not the other, and you have to stick to it. So it is not acceptable that the banner is only a simulation that can be easily checked and verified, and actually the local authority does that. And also consent cannot be, the consent has to be active. So you cannot in any way pre-tick something. For example, in this second picture, the this button off, it could not be already on, and the person has to click for it to be off, or we have seen that, for example, scrolling the page is like consent. So nothing like that is possible under the GDPR. The person has to actively give it consent. Moreover, you have to retain these consents to prove that if you have processed the data on the basis of consent, that you had this legitimate purpose. And when the person withdraws their consent, then this processing activity should be stopped. Data have to be deleted, and you can no longer continue this operation. But as long as the consent was valid, your processing of data was also valid. So it does not have this retrospective effect of looking in the past. So I think very quickly that was it about major GDPR issues. I'm happy to answer any more of your questions, if there are any. If not, thank you for being a wonderful audience.
Are there any more questions from the participants? I think the last two sections of the presentation have been rather complex and heavy for the brain, so late in the evening maybe. I bet all of you calculated along, and that's why I excuse you from having as many questions as at the beginning of the session, of course. But there is a question, I think, from Rainer.
Yes. So use of API also is similar to the use of cookie in a sense that it must have consent. So data subjects in the website where the data are gathered, the privacy policy should have the information that such data will be gathered and that they will be transferred to any other company and how it will be used.
Are there any other questions that you might have for the last minute? All right,
Okay.
Raimond's gonna have one more. Feel free to turn on your mic also if you feel like asking your question that way.
Hi. I will clarify my question. For example, a third-party website have open API, so they are sharing those information kind of sort of way. For example, my website, like I can see advertisement in other website, and I can make this like a small banner from other website. Can I use those data that been used as a banner? If you understood what I mean. For example, SS.com are offering open API, and I can get those advertisements what there is in this website. I can make a banner for my website, and they have like a access link to them. But as there is API, I can also get this data myself, and I would like to do this like deep learning from those data. Can I do that?
Deep learning is a way of AI which the data subjects have to consent to. So the regulation prescribes that people cannot be subject to any decisions by automated means if they have not consented to it. So if you want to do it this way, you have to ensure that everyone whose data you will use has given consent for the activity you will wish to carry, which in reality can be difficult to execute.
Okay. Thank you.
If there are no more questions, I would still like to remind everyone that there's the opportunity to contact me directly to organize a one-on-one meeting with our mentors. There's a limited space availability, but I will see what I can do if you have a very specific case-related situation that was not answered during this session. But otherwise, I would love to give a huge thanks to the mentors. It's not the easiest task to be given in just a couple of hours to go through, but thank you so much for doing this in such a detail and with really applicable examples and calculations and whatever other means might there be to hopefully go through the topics in a more light manner. I think you did just that. I will stop the recording now.